I want to start tonight with a question. How many citizenships can a sitting member of Congress hold? The answer, under current United States law, is that there is no limit. Nothing in the Constitution bars a dual citizen from serving in Congress. Nothing in federal statute requires a member of Congress to disclose a second citizenship. There is no form to file, no disclosure requirement, no mechanism for voters to know unless the member chooses to tell them. The Constitution says nothing about foreign citizenship, nothing about dual allegiance, nothing about holding a second passport. This is not a loophole. This is the document. Tonight, we are going to read the Constitution, read two Supreme Court decisions that make this harder to fix than most people realize, read 3 bills that tried to fix it, and then I am going to tell you where I stand. Let's start with the document. Article 1, Section 2 of the Constitution sets the qualifications to serve in the House of Representatives. Age, at least 25. Citizenship, a United States citizen for at least 7 years. Residency, an inhabitant of the state from which they are chosen. That is the entire list. Article 1, Section 3 sets the Senate qualifications. Age 30. 9 years of citizenship, residency, same structure. No mention of foreign citizenship, no prohibition on dual allegiance. This is not a theoretical question. It has played out in documented recent cases. Ted Cruz was a dual citizen of the United States and Canada when he was first elected to the United States Senate from Texas. He renounced his Canadian citizenship in 2014. No law required him to do so. He chose to. Michele Bachmann held Swiss citizenship through her husband while serving in Congress from Minnesota. This became public during her 2012 presidential run. She renounced her Swiss citizenship shortly afterward. No law required her to do so. She chose to. In both cases, the elected official made a voluntary decision. The decision was not compelled by any legal requirement. The voters who elected them had no formal mechanism to know about the second citizenship, unless they found it through independent research. That is the documented current state of the law. Now, why is it so hard to change? Here is the constitutional wall that every bill attempting to restrict dual citizens from Congress runs directly into. In 1969, the Supreme Court decided Powell versus McCormick. The court held that the qualifications for members of Congress are fixed by the Constitution. Congress cannot add to them. It cannot exclude a duly elected member who meets the constitutional qualifications. In 1995, the Supreme Court decided U.S. term limits versus Thornton, a case about whether states could impose term limits on their congressional representatives by restricting their ballot access. The court held they could not. The qualifications for Congress are set by the Constitution, and neither Congress nor the states can add to them by statute or state law. The principle from these two cases together is clear. The only qualifications that can be imposed on candidates for Congress are the ones written in the document. Any additional qualification, including a prohibition on dual citizenship, requires changing the document. And changing the document means an amendment under Article 5. 2/3 of both chambers, 38 states. This is the same Article 5 wall we documented in Episode 105 on the military draft and Episode 101 on campaign finance after Citizens United. The pattern holds. When a structural question touches the Constitution directly, the only lasting fix is an amendment. And amendments are deliberately hard. That is the wall. Now let's look at the bills that have tried to climb it. 3 bills, 3 Congresses, 0 laws. The table is on your screen. H.R. 946, the Dual Loyalty Disclosure Act from the 118th Congress, the most modest proposal, required federal candidates to disclose any other citizenship, not bar them from serving, just disclose. Even that bill never received a committee vote. died without action. H.R. 7484, the Dual Citizenship Disclosure Act, also from the 118th Congress. Members who are foreign nationals would file a statement with their ethics committee, fines up to $2,500 for non-compliance, disclosure only, no disqualification, never enacted. H.R. 58117, the Disqualifying Dual Loyalty Act of 2025, introduced by Representative Randy Fine of Florida on October 24, 2025. This is the most aggressive of the three. It would actually prohibit a dual citizen from being elected to Congress. The bill's language prohibits the election of any person holding foreign citizenship, barring dual citizens from the ballot without explicitly requiring formal renunciation. As of this recording, H.R. 5817 has been referred to the Committee on House Administration. As of August 2026, 9 co-sponsors, all Republicans. However, here is the critical documented fact. Even if it passed both chambers, it would face an immediate constitutional challenge. Under Powell v. McCormick and U.S. Term Limits v. Thornton, Congress cannot add qualifications for its own members by statute. The precedent runs directly against it. 3 bills, none became law. And the one that would actually change anything faces a constitutional challenge the moment it passes. Here is where I stand, clearly. As my position, if you are going to make the laws of the United States of America, if you are going to vote on the federal budget, on declarations of war, on treaties with foreign governments, on sanctions against foreign nations, on the regulation of trade and the disposition of American military force, your legal allegiance should be to the United States of America. That is not a partisan argument. It is a foundational one. I understand the counter-argument. Dual citizenship is legal in the United States. Millions of Americans hold 2 passports. There is no documented case of a member of Congress acting on behalf of a foreign government because of a dual citizenship. That counter-argument deserves to be stated honestly. But here is what I keep coming back to. A soldier who enlists in the United States military takes an oath of allegiance to the United States. The Selective Service System still requires registration from male citizens who may be called to serve their country. The civic obligation to the nation is real. We have documented it in this series. A member of Congress faces no equivalent legal requirement. They take an oath to support and defend the Constitution, but nothing in the law prevents them from simultaneously holding legal citizenship in another nation. The documents tell us what the path to changing this looks like. An amendment to the Constitution under Article 5. 2/3 of Congress, 38 states, the same path we documented in Episode 101 and Episode 105. Difficult, because it should be. But it has been done before. The qualifications for who can vote have been amended repeatedly in the 15th, 19th, 24th, 26th Amendments. The nation has added to its founding document when it decided the existing document was insufficient. I believe the existing document is insufficient on this question. I believe voters have a right to know if the person asking for their vote holds citizenship in another country. And I believe that the people casting votes on behalf of American citizens should hold one citizenship, and it should be ours. The Constitution's qualifications clauses are public documents. Powell v. McCormack and U.S. Term Limits v. Thornton are public decisions. The documents show that the gap in the law is real. The constitutional barrier to closing it by statute is real. The path through that barrier and amendment is documented and difficult. However, it has been accomplished before when the nation decided it was necessary. This series has now documented the structure of American elections and representation across 6 episodes. Who funds the candidates in Episode 101, how the votes are counted in Episode 102, why the system produces 2 parties in Episode 103, what America builds with its government in Episode 104, who owes the obligation of service in Episode 105, and tonight, who is eligible to hold the seats in Congress. They are all versions of the same foundational question. What does American self-government actually look like when you read the documents? The documents do not always give satisfying answers, but they give honest ones. The question of whether a dual citizen should be permitted to make the laws of the United States is one the documents leave open, and one the American people have not yet formally resolved. You know where I stand. Now you know what the documents say. The documents are in the description. This is Words with Wentz. Know your rights.
Let the signal cut through the noise. Reading between the lines. Every story leaves a trace, unlocking time and space, finding truth with Wentz. Words with